Alan, you're representing yourself, is that correct, ma'am?
Yes, sir.
Oh, okay. And you understand that you've got to either be an appellant or you've got to be an appellee?
Yes.
Okay. And
I
for,
was here with you before.
ma'am? Yeah,
I was here with you.
I recall, yes, ma'am. But I want to make sure, each side gets 15 minutes. Have y'all decided how to share that time?
We have not. We're going to take 7, give this out 8 minutes.
Is that agreeable with you?
Yes.
Okay, that's normally what happens, is that we do, as you've seen before this morning, how we divide time. We don't give extra time, we just divide the time that's there. So what I will do is ask Ms. Angie to give them 7 minutes, give you 8 minutes, okay? And now, since you are pro se, and I realize you've been here before and you understand the process, but is there anything you don't understand or that we need to talk about?
No, sir.
Okay, all right. We're good to go then. All right, Miss Angie, you may call the case. If you have you already called it? Okay, well, forget that then. Let's get it started.
Yes, Your Honor.
Good morning, Your Honors, and may it please the Court. Excuse me, my name is Jeff Nickerson. I'm here on behalf of American Yeast and Ms. Stark, the appellants in this case, here from Memphis, Tennessee. Before I begin, I'd like to reserve 2 minutes for rebuttal.
2 minutes. All right, sir. You may proceed.
Your Honor, thank you. Judge Stafford, as you noted, and I believe you were part of the original panel in this case, on October 4th of 2018, this court handed down an opinion addressing this case in its first instance that it came before this court. At issue in that matter were 2 prior orders issued by the Circuit Court in Shelby County, one order from November of 2016 and one from April 2017. The short version of what came before this court at that time was there was a dismissal of prejudice of the underlying case with a conditional requirement for payment of funds into the registry of the court. At the hearing of this court, which was argued by the parties that are here now, the decision that was handed down in October of 2018 affirmed the dismissal of prejudice in all respects, and that language was specifically in the order, in all respects. However, it removed the interpleader requirement, which was the condition that required the payment of funds into the court. By my math, dismissal plus condition minus the condition leaves dismissal. It's my client's understanding upon receiving that order of October 2018 that this case was dismissed with prejudice. There would be no further proceedings. I can address the contents of the prior orders and possibly will here later on. But it was our understanding that we have a dismissal with prejudice. There's nothing further that needs to be handled, no further litigation or requirements of my clients. Yet we find ourselves 4.5 years back here today. We believe that's improper. We believe the trial court's actions with regards to its interpretation of the order are incorrect. We are here asking this court to undo the July 2021 order that we're now here as the basis of this appeal. We're specifically asking the court to overturn it. Our requested remedy is straightforward. We are asking that the prior orders be affirmed, that the case was considered to be dismissed with prejudice in all respects, that my clients are to be relieved of any further obligations, and secondarily, with regards to the order that's on appeal here, my client was again ordered to pay $300,000 into the registry of the court, which my client did. My clients, excuse me, and my clients would like the money to be returned to them. We believe that the reason for this is well founded on the law of the case doctrine. The law of the case doctrine is obviously very clear. You know, what this court says goes would be the shortest and most colloquial way to put it. But not only that, the prior orders of a trial court stand as the law of the case. In this case, as the court is probably aware, there was a settlement that was signed off on by my clients, but also by Evelyn Allen, who at the time of the mediation and at the time the post-mediation agreement was put into writing, held a general durable power of attorney to handle the affairs for Miss Allen, including her legal affairs. The settlement was reached, but the settlement just simply wasn't to pay money. The settlement was there would be a number of items that would be delivered to my client, including a signed release, proof of payment of liens, satisfaction subrogation, and other deliverables. What happened following that was Ms. Allen revoked the power of attorney. She obviously has a right to do. She no longer wanted to work with her counsel, and she steadfastly said that I'm not going to comply with this post-mediation agreement because I don't agree with it. There were multiple hearings which resulted in the orders of November 2016 and April of 2017, in which there were attempts to basically see that this agreement would be completed. My client wanted it completed. They offered to pay the money. They wanted to settle the case. But my clients simply wanted, in return for the $300,000, is what we bargained for, not just a dismissal, but the other deliverables. Those were not provided. And in November of 2016, the court said that the parties have to comply with the terms. Well, that means Ms. Allen had to comply. We then get to the April 2017 order, and the court specifically notes in that order in paragraphs 13 and 14 that Ms. Allen was explicitly directed by the court on March 13, 2017 to sign the release and to return it to my firm by a set date and time. That did not happen. The court memorialized that order and the lack of response to that order in the April 2017 order. And then on that basis, as well as other failures with regards to the orders of the court, specifically the November 6, 2016 one, the court said that Ms. Allen has disobeyed these orders and I'm dismissing the case with prejudice under Rule 41.02, which, as the court is aware, operates as a merit adjudication. There's nothing further to be decided. There are no other issues that need to be taken up. I've already discussed the fact that we came here in the first time and the decision was rendered in 2018. Now we find ourselves back here because it is the interpretation of the trial court that her orders always meant that the case will be dismissed upon payment of funds. We disagree with that. We think that's incorrect based on the prior orders of the court and the decision of this court in 2018. But we also note that the trial court appears to be going farther this time. Specifically, the order this time around states that the court never intended to just dismiss the lawsuit, even as a form of punishment for noncompliance. Well, the order is very clear that the dismissal was due to the failure of Ms. Allen to comply with orders, and the dismissal is pursuant to Rule 41.02, which allows dismissal for failure to follow an order or directive through the court.
So what prompted the trial court to reinvest itself with jurisdiction here?
Well, what happened is that shortly after this decision came down, I think it was the January following that, there was a petition for attorney's fees that was filed by Mr. O'Neill. And it was filed against Ms. Allen, but it also included American Yeast, my client, one of my clients, seeking payment of those fees and saying that my client was responsible for paying those fees, the $100,000 that he was seeking plus expenses. That continued to embroil us in this case. After that point in time, there were additional motions filed to deposit the funds in which these issues were litigated over a matter of years. Our position is what we've said in this brief, and I'm trying not to just repeat the law of the case doctrine and repeat my brief, but we argued, look, Your Honor, the law of the case here is very clear. You know, we're out. There's nothing further for us here. Judge Higgins, for her particular reasons, disagreed with that. We don't think she's correct, and that's why we're back here today. Judge Higgins made clear, and we cited it in our brief in various hearings, that she said, well, my intention always and ever was that this matter will be dismissed upon the payment of funds into the registry. That condition was there, even though this court said we're setting aside the interpleader, which was the basis for the funds to be put in that first go-round, is gone, and it does not exist anymore. She's still saying that that was a condition that she insisted on. We think that misreads the order of this court. We think that's error. We also think that the court is going against her prior orders. In paragraph 9 of the order that we're here about today, Judge Higgins specifically put in writing, this court does not believe Ms. Allen's failure to sign the release is significant, but notes the signature was something the defendants wanted in this case. Well, that's contrary to the orders I addressed earlier. The April 2017 order said very clearly that she failed to comply with the court's order to do that, and that was one of the bases for dismissal. The whole point of the law of the case doctrine is to prevent relitigation of issues. I say this honestly, as an attorney, I love coming into court and arguing in front of judges and presenting cases, but I also say on behalf of my clients, we would prefer not to be here today. We've obviously expended time and energy and fees over the last 4.5 years, money we cannot get back, because one of the things that we requested was in the release was that we would have a hold harmless if we had to continue litigating issues related to this. We never got the signed release. My client is now spending these fees coming here today.
Well, at the risk of oversimplifying this from your perspective, unless the court has jurisdiction of Mr. O'Neill's petition for an attorney fee, then the court has no jurisdiction. Is that an oversimplification?
Yes, Your Honor, that gets to the issue that was raised on, but I think Ms. Smittick is going to address with regards to the attorney's fee petition being dismissed without prejudice and their argument that it should have been transferred. But our position on that is that, yes, Judge Higgins never had jurisdiction over that question at all. The Starks case is very clear with regards to a charging lien, which is what we understand to be asserted here, is that a separate legal proceeding has to be filed. Not only that, as we look at the statutes with regards to an attorney's lien, the issue with regards to an attorney lien is between client and lawyer. It does not involve a litigant on the other side of the V, for lack of a better term. We believe we were improperly included in that. We believe that there was no jurisdiction. We also appointed Judge Higgins, and Judge Higgins did understand this case, the Castle against David Dorris logging case, which ironically involved Judge Higgins originally, which basically said the trial court can't deal with something like that. It was almost substantially similar to the facts here. So no, we don't believe that there was jurisdiction with Judge Higgins in this specific action. Now, what Judge Higgins did point out in her colloquy on this, that if they go and they refile a separate petition under a separate case number and it lands in her division, that would be different. We don't disagree with that, but the petition was brought under this specific case number in Shelby County of the underlying litigation. And yes, we agree that our argument and position is there is no jurisdiction over that. Okay. As I was explaining, we've obviously had to spend 4.5 years litigating this. One of the arguments has been raised in opposition as well. If we don't pay this money in, we basically reap a windfall. We respectfully disagree with that contention. As I've pointed out, we sought to have this settlement enforced. We wanted this settlement enforced, but we also wanted what we had requested. We did not get that. That formed the basis of the dismissal. The trial court continues to persist to say that my client needs to pay money into the court, which it has, with regards to the court's order. But I'd point out to the court with respect to that, even though we paid the $300,000 into the court, we've still not received the benefit of the bargain that we sought. My client reaps no windfall here. My client has continued to pay attorney's fees to come here. My client has complied with the order of the court to pay the $300,000 in, and we stand here today with none of what we bargained for back in July of 2016.
Well, in conjunction with what Judge Stafford just asked you, based on this court's affirming of the dismissal in all respects, other than the interpleader, did the court have jurisdiction to order you to put that money into court?
We don't believe so. Let me back up just a little bit. In the first appeal, the interpleader request was dismissed because this court concluded that Mr. O'Neill filed a motion subsequent to him being terminated from his representation.
Right.
We had filed a brief in that case arguing that the interpleader was incorrect on the basis of the rule itself. This court never got here. Our position is, however, is though that the interpleader was the sole basis for the funds to be paid into the court. Because that was removed, there's no basis for it going forward for us to be ordered. Dismissal with prejudice meant the case is done. Ironically, my time is also done, and I thank you, the court, for its time.
You can,
Was that
you can
money, was
answer.
that money then never removed from the court? The money that was the money paid in pursuant to the interpleader?
This go-round,
No, did you get the money back from the interpleader?
it was never paid in the first time.
Never paid in, all right.
Yeah. We paid in this second time because the order was formulated differently, and it said we had 30 days to pay in within date of entry of the order. Our determination is that, so we did not come up here and run into a potential issue of everything being finalized for appeal. We paid in this time because the order was formulated differently.
Okay, and that was my question. At the time that you paid it in this time, did the court have jurisdiction to order you to pay it in?
Our view is the court should not have had jurisdiction because the case should have been over, based on these prior orders.
All right, thank you.
Thank you.
Thank you, sir.
I'm gonna try to get you guys to lunch. If it may please the court, I'm Darrell O'Neill, and I represent the estate of John Walker and Darrell O'Neill. Your Honor, counsel started this case off with 2 points from the previous order, and that is the law of the case. And I want that to marinate just for a minute, because he said the law of the case. There was 2 issues that came to this court in the original case. Number 1, should the post-mediation agreement, should it be enforced? That was number 1. This court affirmed and said it should. The second issue was, should Ms. Allen be held in contempt? This court said no. So the law of the case is Ms. Allen's, that post-mediation agreement is enforceable, and that Ms. Allen, the court rightfully did not hold Ms. Allen in contempt. Now-
Didn't the case also say that you didn't have authority to seek interpleading of the funds?
It did.
And that's what it vacated.
It did, but funds that was never put in.
I understand, but the question was whether or not you had the authority to represent,
To file that petition
file that
to
petition
interpret.
to seek the interpleader.
Right.
And the court vacated that and affirmed the dismissal.
It vacated my interpleader, but it didn't vacate the ruling. Because it vacated, see, what the court did and vacated
No,
it.
correct, it vacated the interpleader.
Correct.
And it affirmed in every other respect, which included dismissal with prejudice.
But it also enforced the post-mediation agreement. And the post-mediation agreement gave, and I'll go back to that in a minute, but the only reason why the court didn't make any ruling at all about the $300,000, it just said a document that I filed, it didn't say that the court couldn't force them to put the money in. It just said that I didn't have the authority to request it. It's a real thin line here. And so,
Well, what we're here about today, though, is your attempt to enforce a lien on your fee.
we're here for
But
two
the
reasons.
case itself, the underlying case, has been dismissed. I mean, it's a very peculiar set of facts we have here.
And I disagree that the underlying case had been dismissed, Your Honor. And here's the reason why I say that. Rule 43 specifically deals with remand. And Rule 43 says that a court on a remand can clarify their orders. So when you said remanded to the trial court, you gave the trial court authority to clarify its order. And that's all the court did. The court even said, you all knew I didn't intend for this case to be dismissed as a sanction against Ms. Allen. And that's what they're seeking right now. They're saying that Ms. Allen, that you said, and that the trial court said Ms. Allen should be sanctioned. And that was never the case.
Wait a minute, you're saying that in the court's prior order that came up on appeal that said that this case was dismissed, the trial court's order said the case was dismissed.
Subject to the money being paid. But see, the trial court went on one step further. It said that since I had filed that petition for interpleader, that the money needed to be interpleaded into the court. This court said that I didn't have authority to file a petition for interpleader. This court never said, at no point said that American Yeast didn't have to pay the $300,000. You never said that. You said that you affirmed the court's ruling in all respect. And one of the things that the court ruled, that the post-mediation agreement was enforceable. So if you take the post-mediation agreement and it's an enforceable, well, here's what the post-mediation agreement said. Number one, American Yeast to pay the total of $300,000. That's the first term in the post-mediation agreement that you affirmed. Number two, by entering the settlement agreement, Ms. Allen will also execute a release. Number three, agrees to execute necessary documents to cause the dismissal with prejudice. Number four, further agreed to indemnify. The reason why the court specifically stated in her order,
And she's continually refused to do any of those things.
but they refused to do number one, which is pay the money.
Let me ask you what I consider to be a real simple question.
Yes, sir.
What authority do you have to ask the court to do anything in this case?
I have standing because, number one, because in the standing, again, at no point that either side ever raised standing as an issue, okay? But the way I understand the law, standing is a three-pronged test.
Is it standing or jurisdiction?
It's standing. Whether I lack standing to make this argument on, because the court remanded the matter back.
But you're a stranger to this litigation.
But what I did is I filed, and that goes to my 16-1-116 argument. I filed a brand-new petition to enforce my lien. Okay, they had not paid that money. So I filed a brand-new petition. I paid a brand-new fee. I issued summons. That's the reason why I said that the court should have transferred the case versus dismissing the case.
Then why was it put in this case?
Again, I filed a new petition. I filed a new petition. I paid the fees. I paid the summons.
You didn't get a new number.
I did not get a new number. I did not get a new number.
I mean, and I don't know that that's your responsibility to get a new number or not, but the point is, this can't be a charging lien because the court doesn't have anything.
But
Or
see,
didn't have anything at the time you asked.
and see, Your Honor, I kind of disagree with that. And because the reason why I disagree with that, what you're saying that a remand means that the trial court has no other authority. In a court, if a court's order,
You're putting a very tenuous bridge together.
well, I just pulled a rule. I mean, I pulled Rule 43 up, and Rule 43 gives the trial court authority on a remand.
Gives to clarify its order, not to order additional relief.
Well, and that's what she did. She clarified her order. My intent was never to dismiss this matter.
It's all in the eye of the beholder.
It is. And that's why I always say, whenever you disagree with the trial judge, you come see the three wise judges up here to come up with a final ruling on it. But the issue is, are you issuing sanctions against Ms. Allen? Because that was never done in the original case. And if the answer to that question is yes, then you dismiss this thing. But if the answer to the question is no, then the trial court has to clarify her orders because there was no sanction put in place. Thank you.
Thank you. Ms. Allen, I know you're going to bring clarity to all this.
I'll try, Your Honor.
Okay? We would all appreciate it. If you would, just be sure and pull that mic down a little bit and introduce yourself, if you would. Yes, ma'am.
Excuse me.
And you've got 8 minutes to tell us whatever you
Okay.
want to tell us.
My name is Adriane Allen. I'm a pro se litigant in this case. I'm not an attorney, as you all know. There were several issues that I addressed in my brief. The first one was that the defendants never properly served me based on what they submitted to the court, that they had sent it to me via mail. The email document that they put in their response to my brief clearly shows that their e-file was sent to junk mail, and that's not considered proper. It's on the document that they included. Therefore, their filings, they've not sent me anything, should be stricken from the record. In each, they said they sent it they mailed it to me, mailed me a hard copy. I've not received any. Now, the issue regarding the date of termination of my attorneys remains unclear, because when I orally terminated them in mediation because they were trying to get my parents to take me to court and get a guardianship, because the defendants and my fired attorneys wanted this settlement. When we were here last, the defendants admitted to Judge Swinney that they knew that I had rejected their offer and refused to sign the post-mediation agreement at mediation. Afterward, the only document that I had continued to refuse to sign was that same post-mediation agreement. It was not the confidential settlement agreement, because I did not get that until after August 30th, 2016. Mediation had been July 11, 2016. So what I was telling Mr. O'Neill was, I'm still not signing it because I didn't agree with this. I told you all I didn't want to do this. They were fired. I didn't have any more contact with them trying to get them to represent me, because once I saw that, that they had tried to get my parents to go against me for them to get what they wanted done, and I am the only client on the case. When we were here last, you all stated that there was nothing in the record that said that I was incompetent. No medical records, nothing, to make my own decisions. Therefore, what I said should have been taken as fact, and it should have been followed. They went and had a meeting with the mediator, the defendants, my fired attorneys, and they decided that they were going to try to move the settlement forward. That was in the email that John Walker sent to Mr. O'Neill on July 14, 2016, after the mediation. Yes, I revoked the power of attorney, but it was not because of it being legal for my mother to sign on my behalf with my objection at the mediation. It was because I felt that the trust issue it was broken. Because if I said no, that should have been the end of it, by law. The next point is that once I fired the attorneys, I was chained to the individuals who I accused of malfeasance against me. I did not only accuse my fired attorneys, and I did not only file BPR complaints against both of my fired attorneys, I also filed BPR complaints against the defendant's attorneys, because they had done this in concerted collusion against me to commit intentional fraud upon the court. Everyone, as the defendants admitted, were fully aware at the mediation that I had rejected the settlement offered, and the defendants admitted it last time they were here. Now, opposing counsel has always been aware that my attorneys were fired. They continuously told the trial court that they felt there would be a problem because it was an adversarial relationship that was existing. The court refused to take Mr. O'Neill and Mr. Walker off my case after being noticed. Everything that has been filed is because the court refused to recognize the termination when noticed. This court, in their opinion in October 2018, states that the court should have at least accepted the termination by the time that Mr. O'Neill filed his interpleader motion. Well, that leaves question as to when a client fires their attorney, whether it should be accepted or not when the court is noticed. All of the attorneys were noticed, all of them, that the termination had occurred. The court elected to ignore it. Therefore, that is why we are still in court now. None of these issues would have existed. The trial date was for January 2017. At the time that the defendants and Mr. O'Neill were working together to write the order for the court of November 15, it was admitted that they knew I wouldn't sign the confidential settlement agreement and release of all liens document, and that was because they knew that I had refused and continued to refuse to sign the post-mediation agreement. So as a result, Mr. O'Neill says that is the reason why he and the defendants filed the motion to enforce the settlement agreement, because I wouldn't sign the post-mediation agreement. The court refused to accept that my attorneys were fired, and you've had all of this litigation afterward as a result. If the court had accepted that termination, when issued, none of this would have occurred. The court tried to say the court did say in one of its orders that I was up and down. I have never been up and down. After they did that to me at mediation and tried to bring my parents against me to try to get them to get a conservatorship so they could really move the settlement forward, and then they would sign that second document, which was a settlement agreement. Now, Judge Gibson stated they already had a settlement agreement. Attorney O'Neill had submitted a red line change and placed it inside of that order, stating that the post-mediation agreement was a settlement agreement. Judge Gibson also said that the two documents are the same. They release, they do everything that they're supposed to do. The only difference was the confidentiality piece. So, in essence, on that day was when I found out that there were two settlement agreements. I was never given an opportunity to file an appeal. I was never informed that I could file an appeal, because everything that the court sent went to the attorneys that I had fired, not me. The court continued to refuse to recognize my position as pro se. As I filed, it didn't matter. They said it didn't count. You have an attorney, they sent it all back and didn't file it. I told the court repeatedly, prior to going to court on October 31st, that my attorneys were fired and that I had vehemently opposed the post-mediation agreement entering me into settlement with the defendants. And against my objection, they all signed the document anyway, like I had said nothing. That's why I'm here. The defendants would try to say that I'm just constantly regurgitating things that Mr. O'Neill did. No, they did it too. They all did it together, and they did it intentionally. They meant to do it.
You used your time.
The last point was that,
Nope. You've used your time. We've got your
Well,
brief, though. We've got your
okay.
brief. Thank you.
Thank you.
Yes, ma'am. I believe you got 2 minutes.
Thank you, Your Honor. Let me start with Ms. Allen first. We filed a reply brief that addressed the issues on service. We served her properly. We provided a certificate of service with that. She was served at her email address that has been used throughout this litigation. We disagree with her position on that, and I don't think much more needs to be said on that front. I think, a lot of Ms. Allen's points relate to the underlying case that was, as she was referring to, issues occurring before the prior appeal. But what you heard in her presentation were a litany of disagreements and disputes with regards to her counsel and issues related to that. We already addressed the jurisdictional issue and the transfer issue of the attorney's fee petition. I think that presentation illustrates one reason why a separate action is necessary versus the request that it simply be transferred. It further enforces our point that we're not necessary to that.
Is there a distinction between a transfer and a separate action? I mean, if he's paid the filing fee and done all that, then isn't it just a matter of course to order that it be transferred?
We would disagree with transferring that matter as filed because my client was still a litigant in that petition. That petition should involve only Ms. Allen and her former counsel. With regards to the attorney's fee and any legal malpractice claims there, it should not involve us. Lastly, Mr. O'Neill discusses the vacating of the interpleader, but it didn't vacate the actual ruling for payment. The basis of payment of funds into the registry was the interpleader request. That was the genesis of it. The removal of that removes any basis for that payment. With regards to the argument that he was talking about contempt, we never appealed any aspect of contempt in that previous case. We'd moved for it. We never appealed it. The sole issue that came out of that case was that we did not want to have to pay the funds. We shouldn't have to pay the funds currently.
Thank you. Counsel, Ms. Allen, we thank you for your argument. We thank you for your briefs. We will take this matter under advisement and attempt to render an opinion as quickly as possible.
Thank you, Your Honor.
And we will be in recess until the call of the docket after lunch. Thank you.
All rise.